Welcome to the Mental Health Act and You. This is our second installment of the Advocacy Series webinar with Foundry Virtual BC. I am joined here today with our presenter today, whose name is Iva Cheung. Iva recently completed her doctorate at Simon Fraser University, and her area of research, what she specializes in, is being able to translate medical documents or journals into plain language text to make them more accessible to the general public so that young people and people generally are able to know their rights better, especially as it pertains to the Mental Health Act. So my name is Paige. I'm going to be one of the presenters today. You won't see me, but I'll be here in the background just to be able to support Iva in the presentation. And we're really ready and excited to get started. So thank you, and I'll turn the floor over to Iva.
Thanks, Paige. All right, can you see my slides?
Yes, we can see your slides. Thank you.
Okay, perfect. Okay. All right, thank you so much for having me. I would just like to start out by acknowledging that I am speaking to you from the traditional, ancestral, and unceded territory of the Kakite First Nation. I also have to start with a disclaimer that I'm not a lawyer. I'm not qualified to give legal advice. I'm also not a clinician, so I'm not qualified to give you health advice. A lot of the questions, a lot of you submitted questions before this webinar that I integrated into the presentation. So because I'm not qualified to give legal or health advice, what I've done is sort of reframe these questions as hypotheticals, as what I would do in those situations, given what I know about the Mental Health Act, if that makes sense. And so if I'm not a lawyer and I'm not a clinician, what am I? Well, I'm a researcher. I worked on a project in partnership with people who have experienced involuntary hospitalization under the Mental Health Act. And what we did was we developed and user tested a series of communication tools to help people better understand their rights under the Mental Health Act. So this is one of our products. This is a poster. And on the poster, you'll also see a picture of our pamphlet that we have available. All of our communication tools are available on this website, bcmentalhealthrights.ca, and I'm going to be making a few references to this site. So in the project that I did with people with lived experience, I interviewed 34 people who had been certified under the Mental Health Act, and some of what they told me will appear as quotes later on in this talk. So a few content notes and terminology notes. Because this talk is about the Mental Health Act, I will be talking about involuntary hospitalization, which is when you're detained in hospital under the Mental Health Act against your will, and you can't leave without permission, and also involuntary treatment, so being treated without your consent. And these can be traumatic for some people to hear about, so I just wanted to give a content note about that. Also, I might be talking a little bit about seclusion and restraints. So seclusion is when somebody is locked in a room by themselves, and restraints often is when somebody holds a person down, or the person is tied to their bed to keep them from moving too much. And again, these can be sort of traumatic topics to talk about and to hear about. So I just wanted to give a content note about that as well. I will be making allusions to psychosis, self-harm, suicidal ideation. These are some of the top reasons people are involuntarily hospitalized under the Mental Health Act. And I'll be using the term patients as well to talk about the people who are involuntarily hospitalized under the Mental Health Act. I know that there's all sorts of terminology that people use, from consumers to clients to people with lived experience. And I know patients isn't preferred by a lot of people, but there are kind of issues with every single term that I could pick, and patients is the term that is used in the legislation. So I'm just going to use it for this presentation, acknowledging that not everybody prefers that word. So involuntary hospitalization, you'll also hear it called civil commitment or being committed. And in BC, we also talk about certification, and that's because in order to be involuntarily hospitalized, a doctor has to sign a medical certificate, also known as a Form 4. So that's why we call it, casually, we call it certification. And when you go to hospital, that's also what they'll call it. Okay, so let's start off with what the Mental Health Act is. One of the tools that we created in our project was this video that's available on YouTube that I'll show you. Unfortunately, because I'm on a Mac, I'm not able to broadcast the sound of the video. So I'm just going to read out the captions. But I would encourage you to actually go onto YouTube, search up Your Rights Under BC's Mental Health Act, and you'll get a brilliant narrator who can do a much better job than what I'm going to be doing now. We did create this video for adults, but I will go into some of the differences between adults and youth under 16 after we go through this video. So I'm just going to pull it up here. All right, so let's see if I can do this. I haven't actually run through this while reading out the captions, but we'll see. Okay. Your rights under BC's Mental Health Act. What you can do if you are certified as an involuntary patient. The BC Mental Health Act is the law that sets out the rules for when a person can be certified and kept in the hospital. The law says you can be certified only if a doctor has examined you and believes you meet all 4 of these criteria. 1, your ability to react to your environment and associate with others is seriously impaired because of a mental disorder. 2, you need psychiatric treatment. 3, you need care, supervision, and control to protect you or others, or to keep you from deteriorating substantially, either physically or mentally. And 4, you cannot be admitted as a voluntary patient. If you've been certified, you can't leave the hospital without your doctor's permission, and you may receive treatment against your wishes, but you don't lose all your rights. You have the right to know where you are and why you are being kept in the hospital. The doctor must write the reasons for your hospitalization on your certificate, which you can ask to see. When one certificate is completed, you can be kept in the hospital for up to 48 hours. If a second certificate is completed, you may have to stay for up to a month. After that, your doctor may renew your certificate if they believe you continue to meet the criteria for hospitalization. If you don't agree with the doctor's decision, you can challenge your hospitalization by asking for a hearing with a review panel, which is independent of the hospital. You can have an advocate or lawyer help you present your case, and you can call witnesses. After the review panel hears from you and from the hospital, they will decide whether you meet the criteria for certification. If you would like an advocate or lawyer to represent you at a review panel hearing, at no cost to you, call the Mental Health Law Program. If you don't agree with your psychiatric treatment, you can ask for a second opinion from another doctor. But be aware that your treatment team is not required to follow their recommendations. You have the right to a lawyer, but you may be responsible for the costs. A lawyer can help you challenge your certification by asking a judge to review your case. If you can't afford a lawyer, you may be able to get one phone call to get free legal advice. When you leave the hospital, you may be discharged and be free to go, or you may be placed on extended leave, which means you'll still be certified and still have to follow conditions, like visiting a mental health team for treatment. You have the same rights on extended leave as you do in the hospital, including the right to request a review panel hearing. You can read a summary of your rights on Form 13 or in the Your Rights Under BC's Mental Health Act pamphlet. If you have questions about your rights, talk to a nurse or a mental health team member to learn more. Okay. All right. So again, this video was for adults. But I'm going to give a little bit of a summary of some of the differences for youth under 16. But I just wanted to review the main takeaways of that video. So in order to be certified, you have to meet all 4 of the criteria for certification that are laid out in the Mental Health Act. If a doctor signs one certificate or Form 4, you can be held in the hospital for 48 hours. And then the second certificate, if a second certificate is signed, then you can be held in the hospital for up to a month from the time of admission. So that includes the first 48 hours. You do have rights, even if it might feel as though once you're certified, it feels as though you've lost complete control and you don't have the ability to have a say in your treatment and your freedom, but you do have rights. And some of them only kick in after the second certificate. So we're going to talk a little bit more about that. Okay. So according to the Mental Health Act, you must be told about your rights. You have to be told when you're first admitted, if you are transferred from one facility to another, and every time your certification is renewed. And when you're admitted, if you don't appear to understand your rights, you're supposed to be told your rights again when you seem to be able to understand. Okay, so the way that the clinicians are supposed to tell you your rights is through this government form, Form 13. I don't expect you to be able to read this. I just want you to know what it looks like. So on this form, there will be a place where the hospital can put the name of the facility and their address. And usually it's a nurse who reads this to you. Sometimes it's a social worker, sometimes it's a physician. And when you receive Form 13, they'll ask you to sign it. And a lot of the people that I interviewed for my project were really nervous about this because they said, well, what am I signing? You know, it looks like a contract where I'm waiving my rights. But what it actually is just to show that you have been told what your rights are. So it's just a way of documenting that the staff have taken the steps to tell you what your rights are. Okay, so just wanted you to know what Form 13 looks like. So as I mentioned, the materials that we created were mostly for people over the age of 16. If you're under 16, certification can look a little bit different. Certification might mean that you're being voluntarily hospitalized by a parent or guardian. So your parent or guardian basically authorizes the hospital to hold you, and it's voluntary in that your parent and guardian agreed to it, but you didn't necessarily agree to it. So for the young person, it probably doesn't feel very voluntary at all. Instead of Form 13, you'll receive Form 14, and it's just it looks very similar to Form 13, and a lot of the content is the same. The only notable difference is that you might not be told about your right to a second medical opinion. And we're going to talk a little bit more about what a second medical opinion means. Some things to know about the Mental Health Act is that every province and territory has a different law that sets out the rules for when a person can be certified and hospitalized and treated. So if you move to British Columbia from another province and you say, well, I was in exactly the same situation in Ontario or Quebec or Alberta, and they didn't certify me then, why am I being certified now? That's because BC operates on a different set of rules. And one major difference that BC has is something called deemed consent, which means that if you're certified, you're automatically you sort of lose the ability to make decisions about your psychiatric care. Whereas in some other provinces, just because you're certified, it doesn't necessarily mean that you can can be given treatment against your wishes. Okay, so what certification means in BC is that certified patients aren't allowed to leave the hospital without their doctor's permission. They can't refuse psychiatric treatment. So you can say, I refuse, but they can treat you anyway. So in some cases, that might mean being held and being forcibly injected with something, which can be really, really scary, right? So here, certified patients can't refuse psychiatric treatment. In some provinces, family members can sort of act as a substitute decision maker and either consent or not consent to treatment. But in BC, that's not the case. So especially for people over the age of 16. So as we talked about earlier, under the age of 16, people are, youth can be voluntarily hospitalized under the Mental Health Act on the authority of a parent or guardian. And in that case, family members can give consent to treatment. But if a person is over the age of 16, family members' thoughts on treatment or a person's psychiatric care aren't really aren't legally binding. Okay. And finally, something called advance directives have no power in BC under the Mental Health Act. So an advance directive is a legal document where you can write down what your healthcare wishes are. And under the Mental Health Act, if you do that for psychiatric care, the treatment team doesn't necessarily have to follow it. So it's not a legally binding document the way an advance directive is in maybe other provinces or in other non-psychiatric situations. Just to give you a little bit of an idea of how common certification under the Mental Health Act is. So this is data from 2016 to 2017. Around 15,000 British Columbians were certified in that year, some more than once. So the total number of certifications was about 20,000, okay? And the BC population at that time was 4.9 million, which means that about 0.3% of the province's population had been certified that year. So out of the 20,000 certifications, about 2,000 of them were children or youth up to the age of 19. And for all of the people who were certified, the average hospital stay was 14 days. Okay, so everybody's experience of being certified is different. Some people go into hospital not having a good experience with certification, but afterwards, in hindsight, they come to believe that it was necessary. So this is an example from Bryn Ditmars, who told the Globe and Mail in 2017 that I strongly believe that were it not for these interventions, and he meant forced hospitalization and forced treatment, I would not be alive today. I was a danger to myself and others. It's the best thing that could have happened. So this is just an example of somebody who didn't have a very good time when they were certified, but in retrospect, appreciated that the certification was necessary for them. But not everybody has this kind of experience. It's very variable. So this is a quote from one of my interviewees, Deborah, that's not her real name, who found her certification dehumanizing, even traumatic. She had gone into hospital voluntarily and was certified, and she didn't know she was certified until she tried to leave. So what she told me was, I don't think a single person talked to me like I was a human being in the entire stay. The worst thing about going in as voluntary and having such a horrible experience is I don't trust that system. I don't want to go anywhere near the hospital again. Okay. So here's another quote from one of my interviewees, Ethan, who was more concerned about the boundaries of the Mental Health Act. So what the law allowed the hospital to do and what it did not allow the hospital to do to him while he was certified. So what he said was, it kind of felt like they could have done anything and told me, oh yeah, we can do this under the Mental Health Act. And I wouldn't have known. It was just, I had no idea what was potentially going to happen when I got committed. So you can really imagine how incredibly terrifying that could be, right? Just like not, having your freedom taken away and not knowing whether the hospital could do certain things to you under this law, which is why having all of the information about what the law means and knowing what your rights are can be so important to a person's state of mind and sense of control, even when they're feeling really powerless in that situation where they're certified. So I'm just going to do, I know we sort of covered this on the video, but that went by really quickly. So I just wanted to give a quick review of the major Mental Health Act rights. These ones I'm going to just blaze through quickly because they're pretty straightforward and they don't really require you to do anything. They just should happen. Okay, so you have the right to know where you are and why you've been certified. You have the right, and this first section, to know where you are and why you've been certified, that's actually guaranteed under the Canadian Charter of Rights and Freedoms. So it's a constitutional right. If you're detained anywhere, you have the right to know where you are. You have the right to know why you've been detained. Okay. You also have the right to be examined regularly by a doctor. So each of these certification periods. Hopefully, if you're actually in hospital, you're seeing the doctor more often. But some people get released on extended leave, so they're out in the community, but they're still certified. And sometimes their treatment team has to renew their certification. And every time they renew their certification, they have to be examined to make sure that they still fit the criteria. So if you stop meeting the criteria for hospitalization, there should be this mechanism for you to have regular examinations to see whether you actually still meet the criteria. And if you're not, you should be decertified. Okay, the ones that I want to focus on, the rights, you have the right to contact a lawyer. Again, that's a constitutionally guaranteed right. You have the right to apply for a review panel hearing. You have the right to ask for a second medical opinion, and you have the right to have your certification reviewed in court. The ones I'm going to be focusing on are these middle two, because for most of us, contacting a lawyer can be really expensive, and you usually need a lawyer to challenge your certification or to have your certification renewed in court. And court challenges are also very expensive and time-consuming. Whereas if you apply for a review panel hearing to have your certification reviewed that way, they have to give you a hearing within a set amount of time, and it doesn't cost you anything to apply for one. You can also, most people can also qualify for some sort of legal assistance for representation at these review panel hearings. So I'm going to talk a little bit more about those right now, the review panel hearing and the second medical opinion. So let's start with the review panel hearings. So this is sort of like, I mean, I don't want to make it sound more intimidating than it is, but it's basically like a little, almost like a little court case, where you have an independent panel composed of a doctor and a lawyer and a member of the community who is neither a doctor nor a lawyer. So these three people make up the independent panel. This panel has nothing at all to do with your treatment team. So they're supposed to be making objective decisions, okay? So they sit on this panel, and at the hearing, you get to present your side, and then the hospital gets to present their side, and the panel reviews all the evidence and decides whether or not you meet the certification criteria. And you're allowed to be represented. Usually people like to choose having a lawyer or a legal advocate represent them because they know the Mental Health Act, but you can have absolutely anybody else that you trust be your representative. So it could be a family member, it can be a friend, and some people also choose to represent themselves. Although there has been research that's shown that having a representative that's not you actually increases the chances that you'll get the outcome that you want. Okay, so a few more details about review panel hearings. They kick in after the second certificate is filled out. So after the 48 hours, and once you're into that 1 month certification period, you can apply for a review panel hearing. And you do that by filling out the Form 7. The panel only decides on whether or not you should stay certified. They don't make any judgments about whether you should be released on extended leave. They never make any judgments on your medication or your treatment, whether or not you should be in seclusion, for instance. They don't make any judgments about whether you should have passes or certain privileges, so passes to leave the hospital for short leaves, or other privileges. So they don't make any of those judgments. The only thing they decide is whether or not you stay certified. Okay, the panel's decision is binding. So if they decide that you should be decertified, then you'll be decertified. Okay. And then another right that you can have under the Mental Health Act is the second medical opinions. And so this is when you can choose a doctor, a second doctor, or you can allow your treatment team to choose a second doctor to come and examine you and write a report about whether your treatment is appropriate. So this is very, very different from the review panel hearings in the very important way that it is about treatment only, okay? Having the second medical opinion does nothing for whether or not you stay certified and stay hospitalized. It's only about looking at whether the the treatment plan that your treatment team has come up with is appropriate for you. And if you don't agree with your treatment and you want to change medications or something, and your treatment team isn't responsive to your requests, then the second medical opinion is what you might want to apply for. Okay, so again, this is available after the second certificate. And as we mentioned in the video, it's not binding, it's just a recommendation. So you might think this sounds kind of toothless. You don't know how useful it is to ask for a second medical opinion. This can be really, really useful if you are already working with somebody that you really trust. So let's say you have a psychiatrist in the community that you've developed a really good therapeutic relationship with, and when you're certified, you end up in the hospital with a psychiatrist who doesn't know your history, who doesn't know what you respond to, and who decides to treat you in a way that you don't agree with. A second medical opinion is useful for bringing in the voice of that really trusted psychiatrist that you've been working with, where they can offer their opinion to maybe help you reach your recovery goals. Okay, so now I'll venture into the questions that I received from the Foundry team before when I was preparing this presentation. And what I found was that the questions that I got sort of fell into two categories. So the first is, how do I advocate for somebody else? And then the second is, how do I advocate for myself? So let's talk about advocating for someone else first. So what is the best way to advocate for someone else? The first step, I think, is to help the patient understand their rights. So as I mentioned, all of the rights tools that we developed, that includes a pamphlet, wallet cards, posters, and the video that I showed you, but you can actually access its original narration, which is much better than me talking and reading out the captions. You can access that through bcmentalhealthrights.ca. There you'll also find our pamphlets and our wallet cards, as well as video captions that are in 8 languages other than English. So if you work with somebody who doesn't speak English as a first language and they want to know more about their rights, this is a resource that you can tap into as well. Okay. Another way you can help somebody understand their rights is this resource that was developed at BC Children's Hospital. bcyouthmentalhealthact.ca is how you can access it. So it was developed especially for youth. I will say, though, that for our resources, the ones you can find at that top link there, those were developed specifically in cooperation with people with lived experience. And they were the ones who sort of wrote the first draft, and we developed the suite together. And in that second link, it was developed from a clinical team's perspective. So I'll leave it up to you to look at both resources and see what might be more appropriate for the person you're supporting. So this is just a screenshot from the BC Children's Hospital resource. It's, again, aimed specifically at youth. It's a little bit longer than our 3-minute video. I think it's about 12 minutes, but you can go through it chunk by chunk, and it's a little more detailed in explaining especially the youth perspective and how hospitalization at BC Children's might look under the Mental Health Act. Okay, so in addition to helping a patient understand their rights, if you want to support somebody, you can also help them exercise their rights. So as I mentioned earlier, an involuntary patient has the right to apply for a review panel hearing or a second medical opinion, but they don't have to do it themselves. If they're having trouble with it, anybody can help them apply on their behalf. So if that's some way that you can support a person, of course, with their consent, that's something that you can do. You can help them fill out the forms and submit it on their behalf. Another way that you can support somebody if they choose to apply for a review panel hearing, for instance, is to be that patient's representative. As I mentioned, a lot of people choose to have a legal advocate or a lawyer represent them, but sometimes they choose a family member or a friend. Okay, so you could be that person's representative at a review panel hearing. You could also, if you don't want to play that role, you could also be a witness for that person at a review panel hearing. You can choose to attend that review panel hearing and give your thoughts on why that person should no longer be certified or why they don't meet the criteria for certification. If you're really, really close to somebody, one option that you have to support them is to ask to be listed as their near relative. So this is a term that comes up in the Mental Health Act that describes somebody who's really close or gives care to a person who is certified under the Mental Health Act, and they have certain communication rights. So a near relative does not have to be a blood relative or blood family. It can be found family. It can be a close friend. And the near relative is notified when the patient is admitted, when they apply for a review panel hearing, and when they're discharged. Okay, so on our rights card, which looks like this when you unfold it, it's a trifold card, so it collapses, and it's the size of a business card that you can tuck into your pocket or wallet or bag. When you unfold it, this is what it looks like. And on the back, we've left room for people to fill in information about their mental health team or psychiatrist, and also for their near relative, so that if a person ends up certified, they can pull out this card and the contact information for their near relative and their community psychiatrist or mental health team is right there on the card. It allows for a little bit better communication and some better continuity of care, especially if they're certified in an unfamiliar hospital or unfamiliar area. Okay, so hopefully all of that answered this question that I got while I was preparing the webinar. So the question is, if my best friend was certified under the Mental Health Act, what is the best way I could support them in their understanding of their rights? So hopefully I did answer that question, in that I think you should show them the plain language materials. And I think things are different now with COVID and the restrictions on visitors, but normally I would say one good way to support somebody in the hospital is to actually go and visit them if you can. We would really like to think that all healthcare providers give care to everybody equally, but there has been evidence that shows that having visitors really humanizes a patient and reminds the clinical team that the person has a life outside of the hospital, and it does kind of change the way they're treated, unfortunately, but that's the reality of how humans, I guess, interact with one another. So visiting helps. Also, if you visit often and the care team and the treatment team gets to know who you are and gets to trust you, your presence can also help your friend who's in the hospital maybe get access to passes so that they can leave the hospital for short periods if they're with you, for instance. So, in non-COVID times, I would definitely encourage you, if you're, a best friend of somebody who's been certified, I would encourage you to go and visit and support them. Now with the COVID restrictions, it's a little bit different, but I think it's still important to keep that connection in some way. Okay, so the next set of questions that I got was really about advocating for yourself. So, what is the best way of advocating for myself? Right now, if you aren't certified, but you think you might be at risk for certification, if you've been diagnosed with mental illness, for instance, and you think that one day you might be taken to the hospital against your will, then one way to really empower yourself, again, is to just learn about the Mental Health Act rights, beforehand. I don't want to say before, because it's not really an eventuality that you will get certified. Most people who have severe mental illness don't get certified. But if you are, at least you'll have familiarized yourself with the rights, and you'll be empowered with that knowledge. You know what the boundaries of the Mental Health Act are, and you know what rights you do have, okay? So that's one way of advocating for yourself. Another way is to talk to your mental health providers and make a plan about what you would want your certification to look like. So if you are taken to hospital, who would you want the hospital to contact and tell about your hospitalization? Who would you want your near relative to be? Okay. What treatment options would you prefer? What are your recovery goals? As I mentioned before, advanced directives were this plan that you write down. Advanced directives aren't legally binding, but it's still really comforting for some people to kind of walk through the process and figure out, okay, if this were to happen, even if the team doesn't follow this document to the letter, at least I've thought about what might happen and what I'd prefer. So making a document and making a plan like this can still make people feel better about the prospect of being certified. It makes it a little less abstract and it makes it a little less scary, I think. So I would definitely encourage you to start talking to your mental health providers and your close friends and family about making that kind of plan. Okay. If you do become certified, one of the first things that I would recommend if I were in that situation is to talk to your treatment team. Okay, I think there's a natural assumption that if you are taken to the hospital against your will and you're treated against your will, it's necessarily going to be an us versus them situation where you are in conflict with your treatment team. And I'm not going to sugarcoat it because sometimes that is true. Sometimes people feel very traumatized and violated and disrespected by their treatment team. That does happen. But I think it might be helpful not to assume that just because you're certified, that will happen. Because I do know that there are some amazing nurses who, are trying to work within the law and work within the system, but who really do care about patients' rights and who are really working hard to advocate for their patients. Okay, so do talk to your treatment team if you feel comfortable. I know that some people will just never feel like they can be in a position to talk to their treatment team about their care and their certification because they're afraid that they're going to make things worse for themselves. And that, in some cases is a totally legitimate fear. But there's this enormous power difference between your treatment team and you when you're certified that it can feel like you're very powerless. Okay, but a lot of the clinicians that I've been talking to say that they want dialogue. They want to hear questions about your treatment, about your certification. Ideally, in an ideal world where once you're certified, just because you're certified, it doesn't mean that you lose all control of your treatment. It should still be a dialogue and a negotiation. So maybe you can't refuse treatment, but you can at least, tell your treatment team why you prefer one antipsychotic over another, for instance. I have this as a point here, explain your request. So yeah, ask questions about your certification, like how long do you think I'm going to be here? Ask questions about your treatment. Why do I have to take this antipsychotic? Why do I have to take this drug? And encourage your treatment team in the hospital to connect with the community mental health providers if you already have good relationships with them. Again, it's a continuity of care issue. You want them to be able to, share information with your consent that will let you recover more quickly and get you out of the hospital more quickly. Okay. And finally, I would say, if you're talking to your treatment team, explain your requests. Again, if you just say, I don't want to take that antipsychotic, your treatment team might interpret that as you being defiant or you being difficult. But let's say you say, well, please don't put me on that antipsychotic. I've tried it before, and last time I was on it, I had a full body rash that lasted for a month. Explaining why it won't guarantee that you'll get the outcome that you want, but I think it increases the chances. Like from my perspective, I think that it increases the chances that at least that you'll start developing a little more of a relationship with your treatment team that isn't just based on an adversarial kind of system. Okay. So if all of that, if you've tried talking to them, if you've tried reasoning to them and they don't help, do exercise your rights. Okay. Apply for a review panel hearing if you want to challenge your certification. Again, review panel hearing is for challenging certification. Second medical opinion is for challenging treatment. Okay, so to the questions now. If I don't understand my rights and hospital staff aren't able to answer my questions, what should I do? Where should I go next? Okay, so this report, Committed to Change, was published in 2019 by the BC Office of the Ombudsperson. They did an investigation of people certified under the Mental Health Act and found that 51% of patient files didn't have a Form 13 or a Form 14. So that suggests that 51% of patients, there's no evidence that they were properly told or informed about their rights under the Mental Health Act. So one of the recommendations that the BC Office of the Ombudsperson issued was to have an independent rights advisory service created. So this would be a completely separate service where the staff, their only job would be to go into hospitals and explain rights to involuntary patients, and then, answer their questions about their rights. And if they need help applying for a review panel hearing, for instance, they can start helping them. So that was the idea of the Independent Rights Advisory Service. The recommendation in this report was that the service be started no later than April 1st, 2020. Now that hasn't happened. I actually don't know what timeline they're working on now. COVID might have interfered with that timeline, but I know that there were also, that I don't know that they would necessarily have met this timeline anyway without COVID. But the fact is that this is proposed, and I think maybe it's still in the works. But ideally, this would have been in place so that if you do have rights questions, you would be able to reach out to this Independent Rights Advisory Service. So hopefully this is still coming. And if it does, that answers the question. If you don't still have rights about questions about your rights, you would contact this Independent Rights Advisory Service and you would ask questions. Okay, but given that this doesn't exist yet, what do you do now? If you have questions about your rights, I think the best thing to do would be to try to talk to a lawyer. If you don't have access to a lawyer, you can get an appointment to talk to a lawyer for half an hour for free under Access Pro Bono's mental health program. So these numbers will not, if you call these phone numbers right now, you won't talk to a lawyer directly. What they'll do is they'll book an appointment with you to be able to talk to a lawyer. And then once you are in that situation and you're talking to the lawyer, that's when you can ask questions about what your rights are, what you can do, and they'll be qualified to give you legal advice, unlike me. Okay, so hopefully that answers that question. The next question is, what are my rights if my parent or guardian gives consent for me to receive a certain treatment, but I don't want it? Now, this is super tough. This can happen only for people under 16 who are, again, voluntarily certified under the Mental Health Act on the authority of a parent or guardian. And unfortunately, in that situation, the patient doesn't really have that many rights to challenge the treatment that their parent or guardian has consented to. But I would still, if I were in that situation, I would still try first to talk to the treatment team about why there's that treatment that I don't want. And then if that doesn't work, then you might not be able to access the second medical opinion. Again, that may or may not be available depending on the hospital, may or may not be available to youth under the age of 16. But you can always apply for a review panel hearing that deals with your certification and not your treatment. But with youth under the age of 16, that's sort of the only and best option in terms of rights that you have available. Okay, so I wish I had better news, but again, I am not going to sugarcoat. This is just the reality of the situation for people who are voluntarily certified, who are under the age of 16 on the authority of a parent or guardian. Next question, can I give or refuse consent for certain types of treatment in advance? So as I mentioned earlier, advance directives have no legal power. If you do make a plan and write down like what treatment you've tried in the past, what treatment works for you, what treatment has not worked, then that's better than not having a plan, I would say. Your treatment team doesn't have to follow it, but at least you give them a little bit of a starting point. So no, in legal terms, you cannot refuse consent for psychiatric treatment, but the Mental Health Act applies to psychiatric treatment only, which means that you can always refuse consent for a medical treatment, okay? So for instance, there were all of these horror stories of people who were in institutions who were sterilized against their will. And so the Mental Health Act, under the Mental Health Act, you cannot, they cannot force that kind of medical treatment on you, right? So if they propose a drug or a surgery that affects you medically instead of psychiatrically, then you can always refuse consent for medical treatment. Okay, next question. What can I do if I have concerns about the treatment I'm receiving while I'm in an inpatient facility? Okay, again, this is tough because in the immediate moment, all you can really do is talk to your treatment team. And then if that doesn't work, you'll have the option of applying for that second medical opinion. But I can understand why, while you're in that situation, you can feel really disempowered and it can be really, really scary, right? But yeah, do talk to your treatment team. It is sort of, the ideal situation is you're still trying to negotiate with your treatment team about what's best for your recovery trajectory. And some treatment teams are better at listening to patients than others. And so I would say that, you should at least try talking to them. And if not, if that doesn't help, then do apply for a second medical opinion if you're over the age of 16 and were certified as an involuntary patient. Next question I got is, what can I do if I think my rights under the Mental Health Act aren't being respected? So in the moment, that would be really hard. Try to get somebody you trust to help advocate for you. You can also inform the staff if you know what your rights are. You can tell them that you know what your rights are, and you can tell them about which right you would like to exercise, right? So as I mentioned with that BC Office of the Ombudsperson's report, they found that a lot of staff had been violating people's rights by not telling them about their rights or telling them incorrect information. And I think in a lot of cases that's not down to malice. I don't think that it's clinicians doing something to hurt people on purpose. In many, many cases, based on my research anyway, it's that the clinicians don't have very good training on the Mental Health Act and they're not fully informed about what the legislation says and doesn't say. So especially if you were in like a medical unit, but were certified in like a non-psychiatric unit where they don't deal with the Mental Health Act all the time, a lot of those clinicians don't really have as much familiarity with the Mental Health Act, and so they could be confused about what your rights are. So if you can say, well, I know that I have a right to do this, then that might help. Again, I don't want to sugarcoat things. Sometimes people are very disrespectful to patients and their rights and their right to autonomy. And so I'm not going to say that your experience is necessarily going to be really great if you talk to them. This is just what I would do if I were in that situation. Okay, so in that moment, for the short term, I would try to get somebody to advocate for me. I would also talk to the staff about what my rights are, show them the receipts. Go to the base, if you have access to the internet, go to the BC Mental Health Act, Mental Health Rights website and pull up some of those resources and say, this says that I have these rights and I would like to exercise these rights. Okay, but in the long term, if what you're concerned about is how you were treated and you don't want the system to treat other people in that same way, you can log your complaints. about the way you were treated, about the way your rights were violated with your health authority's patient care quality office. And you can contact the BC Office of the Ombudsperson. The reason they did that whole investigation that led to this massive report with all of these recommendations that are affecting policy now is that people complained, right? So if you had a bad experience, then I'm sorry. And these are some people that you can reach out to try to make things better for people who are coming through the system after you. Okay. Okay, I think last question here is, how do I advocate for myself when I'm not feeling confident? This is really tough. And so I think one thing to do is, when you're not certified in that moment, this is why it's important to kind of learn the rights beforehand, and also to memorize them so that you've practiced talking about them a little bit. So when you're in that moment, it's less, you're sort of doing it because you've practiced it and it's part of your knowledge. Okay, so I would urge you to learn about it and practice the rights, memorize them. Again, make a plan, talk with your friends and talk with your community health, mental health providers about this plan, about who's going to come advocate for you, or support you to advocate for yourself. And having this plan, I think, will make it easier for you to sort of visualize what would happen and what you would say. But ultimately, yeah, I mean, there's going to be some situations where you're feeling that huge power imbalance, and it's going to be really hard to advocate for yourself. So that's what I would recommend. But again, it's not a magic bullet, right? It's not necessarily going to work in every situation. It's just really going to depend on your context and your treatment team and the attitude they have towards you and towards the system. And so yeah, it's really tough. It's kind of roll of the dice, really. Okay. Now, I would be remiss if in this presentation I didn't talk a little bit about Bill 22. Bill 22 is a proposed change to the Mental Health Act that was introduced by Minister of Mental Health and Addictions, Judy Darcy, in June. And what it is, it's a proposed change to the Mental Health Act that would allow a hospital to detain youth for up to 7 days to get stabilization care after an overdose. So you could spend an entire one of these hour-long webinars just on Bill 22. There's a lot of details, so I'm not going to go through all of them, but this is really just the gist of it. It would allow the hospital to keep somebody for up to a week after they've had an overdose and were taken to hospital. Okay, so this came about because there were family advocates pushing for legislation because their children or the people that they were caring for would be taken to hospital in emergency situations after an overdose, and then they would be given naloxone, for instance, and then discharged immediately. And then there would be a cycle, and they wouldn't be connected with wraparound care. And so they were hoping that this legislation would allow, push hospitals to do that. Okay, so this bill was supported by clinicians at BC Children's Hospital who ran a pilot project. And unfortunately, I don't know that anything about the pilot project has been published anywhere, so I don't have very many details about what the pilot project looked like or what it found, what its results were. All I know is that this pilot project informed this bill, and it was supported by family advocates. However, it was also vehemently opposed by the Chief Coroner of BC and BC's representative for children and youth. And you'll also find a bunch of open letters and op-eds. So this is from Pivot Legal Society, letter to BC ministers urging against Bill 22's passage into law. They argue, for instance, that it would that detaining youth would discourage them from actually calling for help if they needed help. It would also disproportionately target Indigenous youth. So that's a concern that was in this letter. So there was opposition from these organizations, Pivot Legal Society, from Health Justice, so Kendra Milne and Laura Johnston, who wrote this op-ed in the Vancouver Sun about how introducing more coercive care into the Mental Health Act isn't going to help and could really harm people, because there's no evidence that detaining people against their will for substance use is helpful. And there's some evidence that it could cause that if you detain somebody and they don't get substances for the week that they're hospitalized, as soon as they're discharged, their tolerance is way lower and it makes overdose even more likely. So that's the argument that some groups have advanced. So given all of this controversy, and given all of this opposition, the government had wanted to push this bill through before the end of the summer session, which ends, I believe, at the end of this week. But given all of this controversy, they've decided to hit pause on it. Okay, so they know they're not going to get it passed during the summer session. One of my biggest concerns when I saw this bill was that the people most affected by it, so youth, were not major stakeholders in their consultation process. So I think that's an oversight, and that really needs to be corrected. So right now, they've hit pause on it. They're going to resume talking about it in the fall session. So if you are a youth who's concerned about this bill, I'm not going to tell you what to think about it, but I just want you to get yourself familiarized with the bill, learn more about it. It's called the Mental Health Amendment Act. You'll find the language of the bill itself if you just Google it, and then you'll find a whole bunch of articles, both for it and against it, that you can read up on just to get informed about what the issues are. And then once you've learned about it and made a decision of like whether you support it or you don't support it, I would urge you to write your MLA. And Minister Judy Darcy and Minister Adrian Dix, Health Minister Adrian Dix, and Minister of Mental Health and Addictions, Judy Darcy. So the fall session of the BC legislature opens October 5th. So basically through the rest of August and September, you can learn more about the bill and figure out what your position is, and then contact your MLA during that period. Okay, so I will end there. Again, you can find our materials at bcmentalhealthrights.ca or at Twitter, BCMHR rights, or MH rights, sorry. Yeah, so that's all I have for you today.
Thank you so much, Iva, for that wonderful presentation, and especially for taking the time to talk to us about Bill 22 as well. I know I learned some things myself through that presentation. And thank you to all of us who joined us for the webinar today. We'll hope to see you again the following Monday, and we're going to be talking about youth in care, and we're going to be having a child and youth advocate coming to speak to us. And thank you very much. We hope to see you again, and thank you again to Iva for your time today.